Appearances.
May it please this honorable court, me Olajide for the claimants. I humbly announce my appearance.
May it please the court. This is Ikechukwu Nnemeka for the defendant.
Okay, so this is the judgment of the court between Benjamin Nduka Oku and Chase Express Service Limited. So the claimant by general form of complaint dated 7th of July 2022 claims against the defendant as follows. An order compelling the defendant to pay the plaintiff, an order compelling the defendant to pay the claimant his total emolument in the sum of 37,780,904 naira 57 kobo, broken down as follows. 1, 15 million naira, 15,442,800 naira as gratuity, 18,482,500 naira, 1,095,464 naira as unpaid pension, which ought to have been remitted to his pension fund administrator, Crusader Sterling Pension, and 772,140 naira for payment of the month's salary in lieu of notice, 780,000 naira only as 2022 leave allowance, and 1,080,000 naira as wardrobe allowance outstanding for 16 years, an award of 5 million naira as general damages, and 1 million naira only as cost of litigation. Upon receipt of the originating process, the defendant entered an appearance and filed a statement of defense dated 7th of February 2023. The claimant in turn filed a reply to the statement of defense dated the 4th day of July 2023. Claimant's case. The claimant was an employee of the defendant from the 1st day of November 2005, initially as general sales manager until he was retired by the defendant by the letter of retirement dated the 24th day of March 2022. Before he was retired, he had been promoted to acting chief executive, that in bracket managing director, and had been subsequently confirmed as substantive managing director, a role he held until he was retired. The claimant maintains that his employment was terminated orally by the defendant on the 17th day of March 2022 during a meeting of the board of directors. The claimant then had to write to the defendant board to officially disengage him. According to the claimant, the company was already running a loss, and with 4 successive persons appointed to turn around the fortunes of the company, which was to no avail until his appointment. Hence, he turned the company to profitability, so much so that the company declared a before tax profit of 48 million naira for 2020 and 75 million naira for 2021. Upon his retirement from the company, he was offered a sum of 7,800,000 naira as emolument, which was less than his entitlement. The claimant equally maintained that he was not regularly paid the salary by the defendant from June 2006 to June 2012. And even more, the defendant did not remit his pension contributions already deducted from his salary and the company's contribution to his pension fund administrator, Sterling Crusader Pensions Ltd. The claimant gave a breakdown of his total outstanding salary of 18,482,500 from July 2006 to June 2012, and total outstanding unremitted pension remittance from the month of December 2019 to March 2022, and total outstanding wardrobe allowance of 1.280 million for 16 years at 80,000 per annum, and total outstanding leave allowance for the years 2022 and full gratuity of 15,442,800 based on gross salary of 772.140, calculated in accordance with the defendant's employees handbook. Finally, he also claims the sum of 772.140 as a month salary in lieu of notice. Altogether, the claimant's claimed total emoluments came to the sum of 37.780.904 million. At trial, the following documents were tendered through the claimant and same were admitted and marked as follows. I have all the list of documents marked and admitted as Exhibit C1 to C12 is in body of the judgment. Now to the defendant's case. The defendants admitted paragraphs 1, 8, 13, and 15 of the statement of claim. However, the defendant's position is that the claimant was confirmed as a substantive managing director of the company in 2018, but did not perform his duties to the satisfaction of the defendant. The defendant also averred that the claimant's health issues greatly hampered his performance as managing director, and he went on unauthorized sick leave without handing over to the deputy managing director. This altered the various company decisions. Notwithstanding, the defendant made numerous out-of-pocket payments to the claimant in settlement of his health issues, but the claimant's health issues only grew and he began showing schizophrenic concerns, which created a toxic workspace the few times he was at work. The defendant then retired the claimant as MD during a board meeting held on the 17th day of March 2022 and offered the claimant the sum of 7.8 million in lieu of notice and the option of retaining his official car at the cost of 50% of its depreciated value. The defendant's position that they never approved any employment handbook in the contract of the claimant, but that there were deliberations concerning the approval in the handbook and did not fail to pay the claimant his salaries, allowances, and gratuities. However, the defendant acknowledged the claimant's entitlement to a month's salary in lieu of notice. During trial, the defendant tendered the following document and they were admitted and marked as Exhibit D1 to D4. Now, in the body of the judgment, I have the defendant's final written address. I have the claimant's final written address. I'll just go straight to the court's decision. I've heard counsel and considered all the processes filed in this suit. It is my view that the following are the issues for determination. 1, whether the claimant was an employee of the defendant. 2, whether the defendant had led sufficient evidence to show that the claimant was retired on health grounds / incapacity. And 3, whether the claimant has led sufficient evidence to prove he's entitled to the relief sought. On issue 1, the defendant had drew up similar questions in his final written address, where he proceeded as follows, and I quote, whether having regard to the claimant's status as a promoter, pioneer, shareholder, and managing director, he qualifies as an ordinary employee entitled to claim emoluments as salaries under employment law, or whether his entitlements, if any, are governed exclusively by CAMA 2020 and corporate principles. It is a law that a company is a separate legal entity after incorporation, and it is therefore distinct from its promoters and is free to contract with and deal with anyone in accordance with its constitution. And CAMA 2020, see the case of Major Concept Ltd versus ZZ 2025, where the Supreme Court held thus, and I quote, upon incorporation or registration, a company becomes a separate and distinct legal personality from the members or shareholders. Being a separate and distinct legal person in the eyes of the law, it can acquire property and enter into contracts. However, it is the law that confers on such an entity a legal personality, but it is not like a natural human being. It is incapable of acting on its own, being only an artificial person. So its functions are carried out by natural human beings who serve as the brain and mind of the company. Grimstar Commodities Ltd versus FCMB and Dancer Foods versus Ison. Citation provided, end of quotation. Furthermore, a company after incorporation has the power to appoint, hire and employ staff / employees as it deems fit. It is on that premise that the defendant entered a contract of employment with the claimant on the 1st day of November 2005 as GM Sales and Marketing, which is backed by Exhibit C1. The claimant was subsequently promoted to acting MD as can be gleaned from Exhibit C2 and eventually confirmed MD in Exhibit C3. The contract of employment has been tendered in evidence as exhibits, and the defendant has admitted to this fact. Regardless of whether the claimant admitted under cross-examination to being a promoter of the defendant, it has become a relevant history in the light of the incorporation of the company. That relationship no longer exists in the eyes of the law. I think this issue has been resolved as the defendant already admitted in paragraph 1 of their statement of defense that the claimant was indeed their employee. The law is settled that whatever has been admitted needs no further proof. See Ojo and SDV 2026 and CBN and DNA 2021. Citations are all provided. See also section 123 of the Evidence Act 2011. It is my finding, therefore, that the status of the claimant in this suit is that of an employee and therefore eligible to all benefits, rights, and privileges that are normally accruable to an employee. Issue 1 is therefore resolved in favor of the claimant. On issue 2, which is whether the defendant had led sufficient evidence to show that the claimant was retired on health grounds / incapacity, the defendant gave a vivid analogy of the claimant's ill health and incapacity from paragraphs 5 to 10 of the statement of defense. In addition to the averment about the claimant's physical ill health issues, the defendant also claimed in paragraph 8 of the statement of defense, and particularly paragraph 10 of the defendant's witness statement on oath, that, and I quote, the claimant constantly showed schizophrenic concerns as he regularly accused members and staff and management of the defendant of being behind his physical health problems, which in turn created a toxic workspace for the few times he decided to show up to work, end of quotation. The defendant's position is that the claimant could not perform his duties as MD due to hampered ill health, which in turn massively affected the effective running of the defendant. For the avoidance of doubt, recourse will be made to GW1's testimony on the 9th day of April 2025. The dialogue under cross-examination is as follows. Question. At paragraph 6, 8, 9, 10, and 11, you allege that the claimant was not able to perform the duties of his office as a result of ill health. Do you have a letter, query, where the defendant complained about the claimant's performance? And his answer, no, there is no letter / query as per his performance because board was aware of his ill health. DW1 was further asked as follows during his cross-examination. Paragraph 10, you say the defendant showed schizophrenic concerns. Do you have any medical doctor's report in support of that statement? And his answer, we do not have an official medical report, but what we saw shows that. The next question, talking about what you saw, do you have a video or audio record? His answer was no. Flowing from the foregoing, there is no difficulty in arriving at the fact that the defendant has nothing to show to convince this court that the claimant could not perform his duties as MD due to being hampered by ill health. The court cannot follow the opinion of the defendant regarding the mental health of the claimant, as the defendant is neither a psychiatrist nor an expert. The observations made by the defendant ought to have been backed by some medical documentation. It is not enough to merely show that the claimant was ill at some point. More so, Exhibit D1 alone, being received for medical bill, does not prove the incapacity of the claimant. If indeed the claimant's illness was hampering the business of the defendant and he was no longer capable of carrying out his functions and showing up to work whenever he wished, then the defendant should have stated it in Exhibit D2 or issued a report to that effect or a query to establish non-performance. The defendant already admitted under cross-examination to never issuing a query or report about the claimant's health and performance. On the contrary, during the cross-examination of the claimant on the 28th day of November 2024, the defendant counsel asked as follows, and I quote, while you were unwell, were you able to carry out your functions? The defendant replied, yes. A lot of documents were brought to me in General Hospital for my signature, end of quotation. Even more, the defendant has not shown to this court any portion of a handbook, company policy, or any employment terms and conditions that the claimant had breached by virtue of his ill health / incapacity, which had justified his retirement on so-called health grounds / incapacity. Very importantly, the contents of the C6/D2, which is the board notification or letter of retirement dated 24th March 2022, did not state or suggest that the claimant was retired due to ill health or incapacity. This court is hereby convinced that concerning the performance of the claimant on his job, all was well between the parties, notwithstanding his ill health. If the defendant thinks otherwise, then it must prove it. The law has not changed even now. He who asserts must prove. See NBA and Udeagwa 206 and Nobi versus Ficolati 1987 citations are all in the body of the judgment. In line with the foregoing, I must hold instead that the claimant was meritoriously retired. Issue 2 is hereby resolved against the defendant. On issue 3, on whether the claimant had led sufficient evidence to prove he is entitled to the relief sought, the claimant averred in paragraph 3 of his witness statement on oath and statement of fact that an employee's handbook was referred to in his employment letter dated the 1st day of November 2005 concerning his rights as an employee of the defendant, and the contents of the handbooks were adopted as a custom and practice with regards to employee matters. This has been denied by the defendant, especially in paragraph 16 of his statement of defense, where it was averred thus, and I quote, the defendant avers that contrary to the plaintiff's claims, his board of directors did not at any time approve, ratify, or incorporate the use of any employee handbook into its contract of service. End of quotation. For clarity, I shall reproduce the cross-examination of the claimant regarding this subject matter dated the 28th day of November 2024 as follows. Question: during your stay in the company, do you know if any employment handbook was brought to the board for approval? And his answer was, I met an employment handbook which was handed over to me by the outgoing MD. I cannot be aware because at the point of my entry, I was not the MD. Question: so it is safe to say that, to your knowledge, no employee handbook was approved by the board? And his answer, there was a handbook attached to the statement of fact. Look at Exhibit C4. Show the court any place where the board approved the handbook. And his answer was, I met a handbook handed over to me by the former MD, which was the basis for my employment letter. He was also asked, were you management staff at inception? He said yes. And he was asked, and subsequently MD, he said yes. As MD, you are repository of company records and management affairs of the company? And he said yes. The question again was put to him, do you have any record that the handbook was ever approved by the claimant? And he said, I don't know how for 17 years of existence, the defendant could not have a handbook. There was a handbook. If there was no handbook, how do you grade officers and provide for leave and compensation of staff if there was no handbook, and take care of HR matters in the absence of a handbook? From the foregoing and from all the amendments before this court, it's important to state that there is no dispute regarding the fact that a handbook was meant to be issued to the claimant upon resumption of work. Accordingly, paragraph 3 of Exhibit C1, which is the claimant's letter of employment dated 1st November 2025, reads as follows, and I quote, on your assumption of duty, you'll be given your job description, procedural manual, and employment handbook to enable you to understand the expectations of the company from you. End of quotation. Although the defendant has not denied or controverted the contents of Exhibit C1, it argued vigorously that the said employment handbook was never approved by the defendant's board. However, it is the claimant's position that an employment handbook was handed to him by the outgoing MD, and same has been attached to the statement of fact as Exhibit C4, and same was used for the running of the company. So in my mind, the crucial issue the defendant ought to have challenged or clarified is whether an employment handbook was ever handed to the claimant in accordance with the assurances made to him in the employment letter. The contention by the defendant that no handbook was ever approved by the company board is diversionary and unsatisfactory and does not answer all the questions. The defendant is a reputable company, and it will be unbelievable to state that board meetings were never documented. The smooth running of any organization is based on policy documents, handbook, or condition of service, however an organization may choose to refer to it. How welfare policies are implemented is usually drawn from these documents as directed by management. This burden of proof the defendant failed to discharge by tendering evidence, by failing to tender evidence to establish if it was ever an agenda at board meeting and approval was never given, or was put on suspension. Further queries in the mind of the court were, was the claimant handed any employment handbook at all at the point of assumption of duties? Did the defendant unintentionally hand over Exhibit C4, which is an unapproved handbook, to the claimant? The purpose of transverse is not merely to deny, but to create clarity. In Antonio Oil Company Ltd and Amocon 2024, citation provided, the Supreme Court enunciated as follows, and I quote, averments which are generally denied in situations where specifics are required do not amount to proper traverse of the case of the other party, and they rather amount to an admission of the case of the other party. For a traverse in pleadings to amount to a denial, it must be explicit, unequivocal and should not leave anyone in doubt as to the intention sought to be portrayed. A general denial of specific allegation of clear fact is an evasive denial and is no denial in law. See Union Bank and Chimaeze and Okpala versus Okeke citations are all provided. End of quotation. Furthermore, the claimant had averred that he was given the handbook by the outgoing MD and that the defendant already had a handbook before his employment. Even more, the claimant also averred in paragraph 31 of their reply to the statement of defense dated 4th July 2024 that contrary to paragraph 19 and 20 of the statement of defense, the defendant's board did not at any time request the presentation of employment handbook from him. I find that the defendant owes the court the burden of proving that Exhibit C4 was never approved, and secondly, that there was never any deliberation for the approval of any handbook. The position of the law is that the burden of proof rests on the party who will fail if no further evidence is adduced. See Ajide and Kelani, Olatunji and Wahid citations are all provided. See also section 132 and 137 of the Evidence Act. As Exhibit C4 has not been controverted till now, I therefore hold that it is indeed the relevant employment handbook of the defendant, and it shall be considered in the determination of the relief sought. Now, the court will focus on the relief sought. The claimant's claim in relief A is a total emolument amounting to the sum of 37,780,904 naira 57 kobo broken down into sub-individual reliefs. The claimant made a breakdown in paragraph 12E of the statement of fact and arrived at the sum of 15,442,800 naira only as gratuity in line with Exhibit C4 employment handbook. The claimant averred in paragraph 12 as follows: full gratuity of 15,442,088 based on gross salary of 772,140 calculated in accordance with the defendant's employee handbook, thus 772.140, 1 week equals 193,035,000, 5 weeks 965,175,000. Total amount in 16 years equals 15,442,800. Accordingly, page 12 of the employee handbook reads as follows, and I read: end of service gratuity. Terminated and resigned employees with a minimum of 3 years service and above will be entitled to end of service gratuity as stated below based on total emoluments. 3 to 4 years, 3 weeks pay for each completed year of service. 5 to 9 years, 4 weeks pay for each completed year of service. 10 years and above, 5 weeks pay for each completed year of service. The defendant did not lay any evidence to contradict the foregoing breakdown. It simply made a blanket denial of owing any gratuity in paragraph 23 of his statement of defense, and that no employment handbook was ever approved. To my mind, it is not enough to simply deny the position of something. As it stands, it is the defendant's word against Exhibit C4, the employee handbook, which had specifically enumerated the employees' gratuities and how they are to be paid. On primacy of documentary evidence over oral evidence, the law accords a measure of primacy to documentary evidence as against oral evidence. Siogbe versus Asade 209. Citation provided. The burden therefore remains with the defendant to prove that the claimant's gratuity claim is false in light of Exhibit C4. This it can do by showing that the claimant was not entitled to gratuities in the first place, or that such an arrangement did not exist. On when an employee's rights to pension and gratuity can be taken away. The law is that pension rights generally cannot be forfeited under the Nigerian Contributory Pension Scheme established by the Nigerian Pension Commission, PENCOM, and governed by the Pension Reform Act of 2014. Pension contributions belong to the employee once they have been duly remitted into the employee's retirement savings account. As a general rule, pension contribution already credited to an employee's RSA cannot be confiscated on grounds of dismissal, termination, or compulsory retirement. The accrued pension contributions remain in the property of the employee. An employer cannot lawfully withhold or cease pension contribution as a disciplinary measure. The courts have repeatedly emphasized that the pension is a statutory right earned by service and is not a gratuitous benefit that may be withdrawn at the employer's whims. The Nigerian courts generally regard pension as a vested and earned right rather than a privilege. Consequently, dismissal or termination or resignation from employment does not automatically extinguish accrued pension rights. Gratuity, however, is more contractual in nature and may be lost where the governing contract regulation, or statute clearly provide for forfeiture upon proven misconduct. See NEPA versus ADME 207 citation provided. In circumstances where the applicable contract of employment, collective agreement, conditions of service, or statute expressly authorizes forfeiture and is validly invoked, the employee may lose gratuity benefits. Whether an employee is entitled to gratuity will be determined by reference to their conditions of service. Consequently, I therefore hold that the defendant is liable to pay the claimant's gratuities to the sum of 15,442,800 based on a gross salary of 772,140,000 in accordance with the defendant's employee handbook. Relief A sub 1 is accordingly granted and it succeeds. Now, on relief A sub 2, which is for the sum of 18,482,500 naira only as outstanding salary being owed to the claimant from July 2006 to June 2012, with a breakdown as contained in paragraph 12 of the statement of fact. During cross-examination of GW1, he maintained that the defendant regularly pays salaries to the claimant's salary account. However, the claimant exhibited the said salary account from 1st of May 2005 to 30th June 2012 in his reply to statement of defense dated 4th of July 2024 by specifically pleading his Zenith Bank account 100181541 and Access Bank account 00459427764. The claimant averred specifically in paragraph 26 of his reply to statement of defense that the defendant was not regular in the payment of his salaries to this account. On his part, the defendant has argued that the said attached statement of account was neither pleaded nor front-loaded, even more that they were not duly certified computer-generated documents under Section 84 of the Evidence Act. Notwithstanding the arguments proffered by the defendant, it is the law that where facts relating to a documents have been pleaded, the document itself may not be pleaded. In Access Bank versus Ogboja 2022, the Supreme Court restated this position as follows. Documents in support of a pleaded fact can be tendered and admitted even though the document itself had not been pleaded. See also Okeke and Orum and Sterling Bar versus Falola. Citations are all provided where it was also enunciated as follows, and I quote, "It is sufficient if statement of facts relating to documents are contained in the pleadings and not necessarily that the document or piece of documentary evidence must be specifically pleaded in a party's pleading sufficient facts relating to a document goes to show its relevance to the case of the party in question, and once there is no legal bar to its admissibility, the document is admissible. Documents in support of facts need not be pleaded but can be tendered in support of pleaded facts as in the instant case. In other words, a document in support of pleaded facts can be tendered and admitted in evidence even though the document itself has not been pleaded. As the facts and figures contained in the back statement of accounts have already been pleaded in paragraph 12 of the statement of claim, then nothing bars this court from admitting the statement of account in evidence. Furthermore, a court is permitted to look at a document tendered before them and make appropriate use of it even though the document was not tendered in evidence. See Agbaisi and Ebikufore, OAN Overseas Agencies and Bronwen Energy Ltd. Citations are all provided. So in line with the foregoing, I resolve that Exhibit C10, C11, and C12 being already admitted in evidence are proper and relevant evidence before this court for the just determination of this suit. However, I have taken notice of the inconvenient fact that the claimant appeared to have developed an acceptance for the inconsistency in the payment of his salary as far back as 2006. I also consider the fact that the claimant was first appointed General Manager, Sales and Marketing, and thereafter he was appointed as the acting CEO in bracket managing director in 2012, which was eventually confirmed in 2018. It is therefore clear that the claimant has been in management cadre of the defendant company until 17th March 2020 when he was retired. On the 28th day of November 2024, under cross-examination, the claimant was asked if he knew the role of MD functions in two capacities, as the leader of the management and member of the board, as recognized by CAMA. The claimant answered yes. The claimant was further asked if he paid dividends, to which he replied in the affirmative, and that it was only during the period he was MD that the company managed to pay dividends. It therefore begs the question as to why, in over 9 years at the helm of managing the affairs of the defendant company, paying dividends and approving salaries, the claimant did not ever think of sorting out his own salary arrears and allowances. It is my considered view that the claimant had, by his inaction, acquiesced to the non-payment of those salaries. Equity aids the vigilant. A court of equity has always refused its aid to stale demands where a party has slept upon his rights and acquiesced for a great length of time. Nothing can call for the court into activity but conscience, good faith, and reasonable diligence. See Balaize and Kallio versus Kallio stations all provided, where the Court of Appeal held as follows, and I quote, "A claimant who sleeps on his right, even if for a number of years without claiming same or taking steps to protect such interest, cannot in later years make claim to same. In consideration of the foregoing, I find that relief A, sub 2, has nothing to stand on and therefore fails, I so hold." On relief A sub 3, which is the claim of 1,095,464 naira 57 kobo, claimant further tendered exhibit C12 being his outstanding unpaid pension and duly signed by the relevant authorities of the defendant. Again, the only opposition to exhibit C12 is the defendant's blanket denial. Therefore, exhibit C12, having not been controverted by the defendant, must be deemed to be authentic. Relief A sub 3 is accordingly granted and it succeeds. For relief A sub 4, it is for a claim of 772,140 naira for payment of a month's salary in lieu of notice. Paragraph 28 of the defendant's statement of defense states as follows, and I quote, "The defendant further adverts that the plaintiff is only entitled to 1 month's salary in lieu of notice, of which the defendant has in good faith offered to pay the plaintiff his 1 year salary, as well as letting him go with the official car, and the defendant has proceeded to reject all of these offers while in possession of the said official car and its original particulars. The law is settled that whatever is admitted needs no further proof. See Agbanelo and UBN, Anachu versus CSC, Cross River State, and also Section 123 of the Evidence Act. In the light of the above finding, I hereby grant relief A sub 4, it succeeds. Relief A sub 5, which is the claim of 708,000 naira as 2022 allowance. It will be recalled that the claimant was retired by the defendant via the letter of retirement dated 24th March 2022. Again, all that the defendant offered in opposition was a blanket denial. In the circumstance, it is all admitted as uncontroverted and hereby granted. Relief A sub 6, being a claim of 1,280,000 naira as wardrobe allowance outstanding for 16 years, rests on the same shaky foundation as relief A sub 2, for which the claimant has been shown to have acquiesced to. Therefore, relief A sub 6 must equally fail, and I so hold. On relief B, it is tried that general damages are awardable per se upon breach and are compensatory in nature in monetary form as assessed by the court in exercise of its equitable jurisdiction to compensate the injured party for the breach of contract or injury inflicted. The rationale for award of damages in litigated matter of this kind has been further elucidated in Shuka versus Abuwaka 2012 citation provided, when the court stated, and I quote, "The basic object of award of damages is to compensate the plaintiff for the damage or injury or loss he had suffered as a result of the action of the defendant, premised on the guiding principle of restitution in integrinum. That is, putting the plaintiff in a position in which he would have been if he had not suffered the wrong for which he is being compensated." In NACB versus Achagua 2010 citation also provided, the court clarified how general damages are determined thus, and I quote, "One of the characteristics of general damages is that it is fixed by the opinion of the court, such as the law will presume to be the direct, natural, or probable consequence of the act complained of." Accordingly, relief B succeeds to the extent relief B succeeds to the extent that a sum of 1 million naira is hereby awarded against the defendant in favor of the claimant as general damages I so hold. On relief C, which is cost of litigation, this is assessed at 500,000 naira only. All sums awarded in this judgment shall be paid within 30 days from the date of delivery of this judgment, failing which the sum shall attract simple interest at the rate of 10% per annum until fully liquidated. Judgment is accordingly entered. This is the judgment of the court.
Obediently a lot of them. Of gratitude only 15 million. Their damages that we have moved a Sunday salary. In the sense that they in the over day, she saw that house. Something else you want. That's before 30 days. That is the way. With that which I'm a cool interest. So position and what I give you. So you're the one neighbor. So give you what's very out to you, if we are not, but the damages after almost 20. People who eat out, people should be wary. Medical reported. prove ẹ̀.
ṣé wọ́n ṣọ́ ní fídíò ṣọ́ lẹ́yìn
Pé mo dá lé iṣẹ́ rú. Ṣé làwọn jáde iṣẹ́ tó gbà lọ?
ọjọ́ tó ti ń rọ̀
In lieu of notice, leave allowance. Gba damages lọ́lé. Gba damages lọ́lé. So, when the damages is about 5 million, which already is 20 million. Then, leave allowance at the salary is 1.4 already. In lieu 1 month. So that should be about 20. So, ìgbà tá à ń sọ fọ́ba yẹn san sálárì ni san iṣẹ́ ló ní tí ò jẹ gbèsè làwọn fẹ́ san.
Òrùlé máa ti fọ́ ìṣòro pé ìgbà tó wà ń bẹ̀ pé kò bá ti san
ọmọ fi dọ́kúmẹ́ǹtì náà sọ pé àwọn bọ́ọ̀dù approve ẹ̀. That's why I love any document, you keep it. Document yẹn.
orí fídíò onímọ̀ nìyẹn tó kí o gbà pé fídíò lòun. I think the one I talked about married for maybe 10 years. All they do a lot of programs. You will wá ó wá bẹ̀rẹ̀ sí ní because obìnrin méjì ló ń dún sí mọ́ra rẹ̀. Ló wá bẹ̀rẹ̀ sí ní pé fíìmù náà pé ó mọ̀ pé ní tradition wọn pé obìnrin kì í gbọ́n. So all the properties náà ní lẹ́yìn ìgbẹ̀yọ̀ ní ìgbé. Nígbà nígbà wọn ń padà bọ̀. Ó ní ìwọ ń sọ pé ó ní nílò tó ń ṣe nǹkan ìjọba ìṣẹ̀lẹ̀ to teach other videos. You don't just succumb to then all documents. Make sure you keep it. You understand? Then don't just say, oh, you don't know material. Don't just say, don't shame God. Allow hide. You should leave your family alone. So that they have evidence. Only provide a lot of evidence. Because what is often the property is for at least ìgbà tó ní ti ṣe ẹ̀yà tó kí ìlànà tó gbé nǹkan ìfẹ́ ní ti ń ṣe òun that property belongs to our children. Ètò nǹkan kan bá ṣe òun wọn lè gba property yẹn lọ́wọ́ àwọn ọmọ.
Láti ìgbẹ́jọ dọ́kúmẹ́ǹtì DHM FedEx ìtọ́jú ìdí sálárì yìí kì í fẹ́ gbẹ.
Olùdókè kò lè ní mọ́tà olùjì ara ẹ̀mí yìí. judgment ti náà.
Bẹ́ẹ̀ bá ṣe máa ń ṣe ìyẹn, àwọn kan lọ because judgment ló fẹ́ give abaya lọ ṣàdúrà.
Gbogbo ilé wọn kì í ṣẹlẹ̀ kékeré. Bẹ́ẹ̀ bẹ́ẹ̀.
Bí mi ò mọ̀ bọ́ yóò máa dùn.